Good afternoon. My name is Cora Chan. I'm an associate professor at the Faculty of Law. Welcome to this event on Dr. Tarunabh Khaitan's masterpiece, A Theory of Discrimination Law, published by Oxford University Press last year. This book, it truly is a masterpiece. I've read it, so I can attest to that. It provides an original, unifying theoretical account of discrimination law. It is extremely clear, so it's palatable even to newcomers. I won't claim to be an expert in discrimination law, but it's extremely palatable to me. It's extremely clear, it's rigorous and thoughtful, and will definitely shape the understanding and practice of discrimination law around the world. Since its publication last year, it has already been the subject of international attention and has attracted positive reviews by numerous world-leading authorities on the subject. So I would recommend this to anyone, academics, lawyers, judges, students, policymakers, anyone really that is interested in discrimination law. Today we're immensely honored to have with us the author, Dr. Khaitan from Oxford, to speak to us about the book. Tarun is an associate professor and Hackney Fellow in law at Wadham College. He graduated from India's top law school, National Law School of Bangalore. He then attended Oxford as a Rhodes Scholar and completed his BCL, MPhil, and DPhil at Exeter College. He's a renowned authority in discrimination law theory. In fact, he's currently involved in drafting an anti-discrimination bill for the Delhi government. We hope that that's going to come to fruition. He's very kindly shared a draft of the bill that he's been working on, so in case you're interested, you can get a copy over there. In this session, we'll first invite Tarun to speak on some themes in this book, followed by open discussion with the floor. Unfortunately, Pooja is unable to make it due to unforeseen circumstances. She sent her apologies and regrets. The advantage of that is that it's going to give us more time for open discussion. I'm sure that many of us have a lot of questions for Tarun. We all want to tap into your expertise in discrimination law. So without further ado, let's welcome Dr. Khaitan.
Cora, thank you very much. It's such a pleasure to be here and to come to to this university to speak to you about discrimination law. It is hard to speak about one's book because you get so involved in the nitty-gritties and detail of argument as you're writing it. I'm going to just say a few general things, and maybe some of the detail will come out in the questioning. But before I speak to the book and some of the arguments there, I thought I should tell you about my last couple of days in Hong Kong, concluding with my newspaper reading this morning. And it is related, if you will humor me. So when I landed at Hong Kong airport on Saturday, I was taken to an immigration office and asked to wait while my passport underwent special scrutiny. I was assured that this was a random check. Now, as a brown man who travels frequently on his own around the world on an Indian passport, I'm very used to being picked up by random security checks at airports. Being stopped on the streets of Hong Kong yesterday for another random security check was a first and gave me a glimpse of what being black in America is probably like. But the issue of discrimination goes beyond racial profiling. So I picked up today's South China Morning Post over breakfast, and the stories that sprang to me, all in one day's newspapers, were amazing. So on page 1 and 6 of the main paper, I read a story concerning a detergent advert. Some of you might have heard of this already, where a black man is forced into a laundry and emerges as a lighter skinned Asian. On page 7, we were told that around 60% of female Japanese MPs reported to having been sexually harassed. On page 9, there was a story discussing women being sold as sex slaves by IS. On page 7, again, a story from my own country, discussing the rising racist attacks against African nationals in India. On page 8, a black teenager in the United States was removed from his graduation ceremony for wearing his traditional Ghanaian dress. The first page of the business sheet bemoaned the lack of gender diversity in Hong Kongese boardrooms. You might think that newspapers are talking about little else. This is all in one day's paper. And there were silences. On page 6, a story concerning IVF treatments, focused entirely on, it was left unsaid but pretty obvious from the context, heterosexual couples wanting a second child, accessing IVF in China. I wondered what the situation regarding IVF was for same-sex couples. A lot of these stories reveal the changing nature of discrimination. In our times today, we rarely get acts of direct, prejudicial, discriminatory acts. No one, actually. Very rare to see hotels hanging boards today with, say, no dogs, blacks, or Irish. That sort of direct prejudice is thankfully more or less disappeared. What has happened, however, is that discrimination has become subtle. It's a bit like flirting, where you retain a deniability to it. When called out, you can say, I didn't mean it, wasn't happening. And if it's not deniable, it becomes dismissible as trivial. So consider some of the stories that I mentioned, and I was thinking about how so many of them fit with this changing nature of discrimination. The detergent firm, in a half apology, claimed that the ad was not racist, or I don't know what they meant. They probably meant it wasn't intended as racist, and blamed it on an exaggerated reaction by the Western media, which is oversensitive to this kind of racism. Every official who has stopped me in Hong Kong, in US, in Australia, in New Zealand, in Britain, has always been at pains to claim that this is a random security check. Right? And I have to be, any statistical analysis which you have, to be extremely unlucky to be picked up by all these random checks. But the fact that they feel the need to claim that this is random, I think is important. And important in an important way. It is a sign of some progress we have made on, annoying though it is a sign of some progress we have made on issues around discrimination. The Indian government, responding to the stories about attacks on African nationals in India, has said these are isolated incidents and should not be seen as a grand narrative, that these attacks are not racist. They were domestic, individual disputes in each case. And I suppose all of you know about your recent case that Cora introduced me to, the ladies' night case in the bars. Well, for those of you who don't know about it, I'm told that the courts, a Hong Kongese court, said that a bar serving drinks to women at a lower price was violating the Sex Discrimination Act, and therefore acting illegally. One of the newspaper stories about that case quotes someone called Alan Zeman, who, I don't know, the name probably means something to you. It didn't mean anything to me, but I gathered that he was someone important. Reacting to the court's decision prohibiting cheaper drinks for women, said, and I quote, "It's kind of ridiculous. There are bigger problems in the world to worry about than ladies' nights." So this is the second example. Either there's deniability of discrimination, or there is a trivialization of it. Right? Either it's not happening, or it is not important. And all of these reactions sum up these typical responses to discrimination quite nicely. Now, most of these cases are not based on prejudice, they're based on stereotypical assumptions about people, about groups of people. So because of your membership to particular groups, you're assumed to have certain features and characteristics that a brown man traveling alone is likely, well, there are two proxies there, likely to be Muslim and more likely to be a security threat. That being fair-skinned is more desirable aesthetically than dark skin. That women need to be enticed to bars with promotional deals to satisfy the sexual gaze of the largely male patrons. It is also true that in each individual case, the effect is sometimes small, possibly trivial. A few extra minutes at airports, a mere offense to feelings, or even what might seem to be a benefit, cheaper drinks. Sexual harassment, as we know, often involves compliments. So one asks with Alan Zeman, what really is the problem? The problem becomes even worse when we think about indirect discrimination. I quickly looked up your sex discrimination ordinance this morning on the internet. I know nothing about Hong Kongese law, so please forgive my ignorance. That is, the language seems to have been borrowed from the British Sex Discrimination Act, which also recognizes indirect discrimination. So it seems that Hong Kongese law, at least as an outsider, does cover indirect discrimination as well. I don't know if there has been a lot of litigation on that count, but indirect discrimination prohibition is the central question in British and American legal systems because of 30, 40 years of experience with case law on discrimination. Even stereotypical practices are slowly, I wouldn't say being rooted out, but they're hiding. They're changing face. They're difficult to put your finger on. They're harder to call out. And which is why indirect discrimination litigation is becoming really important. For those of you who may not be familiar with indirect discrimination law, the prohibition of indirect discrimination, it comes with an old case in the 1960s, possibly 70s, I might have got the year wrong. In the US, no, 70s, early 70s. It's called Griggs against Duke Power Company. Now, remember that in 1964, the US Congress had passed the Civil Rights Act. The Civil Rights Act, which prohibited discrimination based on race in employment, amongst other things. Now, as soon as that act comes into force, obviously employers start changing their overt behavior, right? So you no longer have no black employment policy. Now, in that case, the defendant is the Duke Power Company, an employer which has a history of white-only workforce. Before the Civil Rights Act, it only employed white people. The Civil Rights Act comes in and it changes the policy in very interesting ways. So it no longer says that we will only hire white people. What it does say is we'll only hire people with a graduation degree. Now, in that context in the US, acquiring a graduation degree had almost the same effect because most black people in 1960s America, in the place where the company was based, did not have graduation degrees. What's interesting about the case is that the job, well, A, the company had never required graduation degrees to do this job in the past, and B, the job had nothing to do with graduation skills that you learn as a graduate. It was an unskilled manual job. Right? Now, the case goes far up to the Supreme Court. What the claimants could not prove in the case was that this policy is a pretext to keep black people out. If they had proven that, the case would have been easy. They would have shown that it's motivated by a racist intent. It would have been direct discrimination. But it's very hard, as you can imagine, to get evidence to prove motives. Right? That this was probably decided in some secret meeting between the company's board and the claimants are not likely to have that information, and the company is not likely to disclose that information voluntarily. Right? So the claimants could not prove a racist intent in the case. what they argue in the court and what the court accepts is that it's not necessary. It's enough, the court says, if the impact of the policy disproportionately affects a protected group, in this case, black people. If the impact is disproportionate, then the burden is reversed. Then the burden is put on the employer to justify the policy. You're still allowed to have the policy if you really need it. In this case, all the evidence showed that the employer does not need this policy, that the employer had worked just fine without the graduation degree, that is a new requirement almost as a reaction to the Civil Rights Act, etc. So it failed the proportionality test. The court called it different things, but anyway, that's effectively it's a business necessity test. And that test has failed, and therefore the court said, and this is American terminology, that the Civil Rights Act prohibits not just disparate treatment, which other jurisdictions call direct discrimination, but also disparate impact. The British Foreign Minister, Roy Jenkins, is on a trip to the US right after Griggs is decided. He's also at this time, this is 1973-74, he's also at this time drafting the Race Relations Act in the UK. Somebody tells him about Griggs. He thinks, what a great idea. Goes back to England and writes it down in his legislation, calling it indirect discrimination. And then it makes its way to Sex Discrimination Act, which is passed in 1975, and the idea travels the world. It goes to Canada, to the European Union, to South Africa, and as I discovered today, to Hong Kong, right? and no doubt many other places. So this is the history of indirect discrimination law. And as societies become better at hiding discrimination, it's the most important tool that anti-discrimination activists and lawyers have in fighting the system. In the US, the trajectory now moves in the opposite direction. Right after Griggs, there is a massive backlash against the case. And since Griggs, the American history has been a history of rollback of indirect discrimination liability. In the 70s itself, the court refuses to apply indirect discrimination law to discrimination by the state. In 1990, it gave this judgment called Rhodes Scholar, which would have made proving indirect discrimination almost impossible in real cases. The Congress intervened to take away some of the effects of that judgment. In 2008, in a case called Ricci, again the Supreme Court made it extremely difficult to prove indirect discrimination, and Justice Scalia openly considered the fact that indirect discrimination liability may be unconstitutional. Last year, in a case involving the Fair Housing Act, the Supreme Court upholds the constitutionality of indirect discrimination, but only by a whisker, and by making so many concessions that it's not clear what impact the disparate impact liability will continue to have in practice. The effect elsewhere has been slightly different. In the UK, in Canada, in South Africa, the liability indirect discrimination becomes entrenched. Although now in Britain as well, there are signs that things are changing. I'll just give you one example of American ideas traveling to Britain. There's a case last year which involved promotions by the British Home Office. It's called ESSOP, E-S-S-O-P. Now what happens in that case is an audit report, an equality audit report that the Home Office itself instituted, reported that the promotions policy that the Home Office has in place, non-white employees have a 40% likelihood of passing that promotions test compared to white employees. And the chances, the report also says, the chances that this disparity between white and non-white employees could be random is 0.01%. So effectively, the report says this is not a random outcome. There are human causes at work. What the report does not explain is why this disparity is there. Why is it that white employees, non-white employees have a 40% lower chance of passing this test compared to white employees? And that becomes important in the case law. Now, under traditional indirect discrimination law, this should have been an easy case. The claimants have shown disparate impact on a protected group, non-whites. It should have been up to the employer, the Home Office, to show that the test was proportionate, to justify it. The Home Office conceded in the court that if the case goes to the justification stage, they will lose. They admitted that they could not justify the policy. Why? Because the policy had nothing to do with the job that the employee is required to do. This is a policy, it was a two-stage policy. The first stage required a generic assessment test. It's like an IQ test that some of you may have taken. It looks at verbal and logical reasoning, etc. And it's the same test that every Home Office employee has to pass. Every employee, whether you're working in IT, whether you're working in immigration, whether you're working in security services, prison services, it doesn't matter what your sector is. So it was completely indifferent to the actual job that you performed as an employee. So it wasn't tailor-made, and that's a classic example of disproportionality. Right? The tailor-made questions came only if you passed the first hurdle. So the Home Office admitted that it could not justify the test under the proportionality requirement. The Court of Appeal said the case does not even get there. Why does it not get there? The Court of Appeal said it's not enough for the claimants to show disparate impact. The claimants also need to show why they face this disparate impact. They have to explain what it is about their not being white that they're failing these tests more frequently than white people. Now, of course, this may be a problem with bad lawyering at the trial stage. Some of the explanations are quite easy to reach. Non-white employees are likely to have had poorer education. They're likely to have been just poorer, come from poorer families. They're likely to have been first-generation employees who did not have cousins and uncles working in the Home Office who could pass on the reading material, who could tell you how the system worked, who could send you to coaching centers. You know, all these soft network benefits that come with being part of a system. So a good lawyer would have solved this problem at the trial stage. Sadly, they didn't have a good lawyer at the trial stage, so they lost the case. It's under appeal in the British Supreme Court at the moment, and we will see what the Supreme Court said. But notice the implication. If the Supreme Court upholds this judgment, except in the most obvious cases, so the obvious cases of indirect discrimination will be a ban on turbans and the impact on Sikhs, inflexible working hours and the impact on women who have more caring responsibilities in our societies. So these are the obvious cases. These will still pass. But the more difficult indirect discrimination cases, where indirect discrimination happens because of a complex mixture of socioeconomic disadvantage, of poor education, poor class, those cases will effectively lose. They will never get litigated. So even in Britain, the status of indirect discrimination law has become really controversial. And remember, all of this with regard to a policy that the employer themselves accept is not designed to do the job. Right? So we're not talking about something the employer actually needs. There's also, just to mention one final factual fact before I move on. So there's also growing evidence growing sociological and psychological evidence that all of us carry implicit biases. That even when we cognitively learn and accept and believe that racism and sexism and homophobia and all the other isms that discrimination law concerns itself with, even if we actually truly believe, sincerely believe that these are bad things, we still tend to share the dominant biases of our society implicitly, unconsciously. If you have any doubt, I would highly recommend the Harvard University's implicit bias test. It's online, you can just search it and take it. I took it, and it's revealing it doesn't matter whether you've spent a lifetime doing work on discrimination. It doesn't matter what your own group is. You share biases against your own minority group. Women have sexist biases. Gay people have homophobic biases. Black people have racist biases against their own groups. So it's amazing how much our implicit thinking is molded by the social context in which we are based. The best we can do is acknowledge that we have these biases and try to fight it. But denial will mean that we cannot even begin. So to my book. Now, in my book, I argue that these isolated cases, and we've seen that the actual substantive benefit at issue can be quite small. Sometimes it's really big, like a job promotion, or even a job, or where you live. Right? But sometimes the benefit can be quite small. Cheaper drinks, a couple of, maybe, few dollars, maybe some extra time. So, and which is what brings the charge of triviality to discrimination. I argue that seen in totality, these incidents, these particular acts, are not isolated. That they are caused by and they contribute to systemic patterns of group disadvantage in our societies. So the reason why we should care about discrimination and discrimination law is that discrimination is responsible for ensuring that groups such as women, gays and lesbians, religious and racial minorities, trans people, the elderly, the disabled, and many others face substantial, abiding, and pervasive disadvantage in our societies. Substantial because the disadvantages that the groups as a whole face are not trivial. That the gap between men and women is significant, for example. Abiding because these disadvantages are stable over time. They are not fragile. They have sustained years and decades and centuries of social evolution. And they're still with us. And pervasive. They don't just affect us in one little aspect of our life. They affect us everywhere. They affect us when we travel. They affect us when we choose our partners and friends, what schools we go to, where we choose to live, where we are able to work. So their impact is on the big decisions in life and the little decisions in life. Where to go to eat tonight, and who to settle down with in your life. And that's why these little acts matter, because in their totality, they sustain this system. They are both the cause and effect of the system of systemic group disadvantage. It's amusing that towards the end of this newspaper, there's a page on star signs, predictions about what will happen today to me, right? And it's been a while since I've read that section, and I didn't actually read. But what is interesting is discrimination law doesn't care about discrimination based on your zodiac, and for good reason. The reason is that our societies are not organized in a way where there are systemic differences between Leos and Cancerians. If there were, if when you went to get a job, your employer wanted to find out whether you were Sagittarian or not, then we would have reasons for discrimination. Not isolated cases. There may well be some eccentric, idiosyncratic employer who only works with Sagittarians. Right? But if you're not a Sagittarian, despite this eccentric, idiosyncratic employer, your quality of life remains unaffected. It's annoying. You may even be very angry, and this employer is clearly acting foolishly. But it does not sustain, this one individual isolated act does not sustain a societal system of significant group disadvantage. But you may ask, why should we care about these substantial, abiding, and pervasive group disadvantages? I argue in my book that they matter because when you belong to one of these vulnerable groups, one or more of these vulnerable groups, your membership hinders your access to three basic liberal goods. At least your secured access to three basic liberal goods. And these goods are freedom from unjustified interference. I argue that women and other minorities are more likely to be interfered with, their freedom interfered with unjustifiably, than members of the dominant groups whose social and economic power protects them from unjustified interference into their freedom. Members of these groups are also less likely to have access to a valuable range, an adequate range of valuable opportunities in life. Valuable opportunities such as education, housing, employment, etc. And finally, these groups are also less likely to have a secured sense of self-respect, which is another basic liberal good. The argument is complex, and if you have questions, I'm happy to elaborate upon it. But that's the big picture argument. In my book, I also make a point about the need for a two-level analysis, that we need to ask different questions about what is the general justifying aim of discrimination law, which is what I just explained, and a lower level question of what should be the rights and duties that discrimination law enforces. Who should be the right bearers? Who should be the duty bearers? I argue that we should not look directly at the general justifying aim to answer these intermediate level questions, that other considerations come into play. So even though men don't suffer as a group from systemic pervasive disadvantage, there may be other good reasons to prohibit discrimination against men as well as women. But again, I'll leave the detail in case anyone is interested. Finally, Cora's already distributed the Delhi bill. I don't know its status in Delhi yet. It seems to be sort of in the cold storage for now. But one of the policy implications that I want to offer, at least given my knowledge of the Hong Kong system, is that it's quite important to see discrimination, the problem of discrimination, not as disjointed silos of race and sex and sexual orientation and religion. It's quite important to think about it comprehensively, perhaps in a comprehensive legislation, because the issue is the common one. The nature of the problem is the same. The groups will change in different societies, different groups may be vulnerable. And over time, the vulnerability of groups may shift. But it's more principled to think about this holistically, and that also solves certain other problems in discrimination law, like that of intersectionality. The problem comes up in the US where a black woman loses a case because she faces discrimination as a black woman, discrimination that black men don't face and that white women don't face, and the court says we can't fit you in anywhere, so you lose. So anyway, with that final comment on one policy suggestion, I will stop, and I'm happy to take your questions. Thank you.
Thank you very much, Tarun. That was excellent. I would like to abuse my position as chair to begin the discussion. You mentioned that the point of discrimination law is to ensure secured access to basic goods for leading a good life, including three things: liberty, an adequate range of opportunities, and appropriate level of self-respect. In your book, you actually offered four basic goods for leading a good life rather than just three. So the first one, which was not included within the aims with that discrimination law would help fulfill, would be a set of material goods that will satisfy one's biological needs. My question is, well, why is reduction of relative group disadvantage that limits access to this first basic good, goods that will adequately satisfy one's biological needs, not the function of discrimination law? So why is discrimination law only concerned with relative group disadvantage in accessing the other three basic goods, namely liberty, adequate range of opportunities, and appropriate level of self-respect? It seems that some of the most serious forms of discrimination concerns limits to material goods, like food. Also, it seems to be hard to distinguish basic goods to satisfy biological needs from the third a basic good, which is an adequate range of opportunities. You mentioned housing, for instance, as an example of a valuable opportunity rather than a set of basic good for satisfying biological needs. So my question is, why is the purview or the concern of discrimination law why is discrimination law only concerned with the three basic goods that you mentioned, but not the first? So why is it only concerned with liberty, adequate range of opportunities, and self-respect, but not material goods?
Cora, thank you. That's an excellent question. So just to put the question in context, the broader argument is that these four basic goods are what liberal states should protect and facilitate, and because these are the four basic goods that we need in order to live a good life. Material goods that fulfill our biological needs, and I mainly have food and clothing and probably shelter in mind. Freedom from interference, unjustified interference, which is largely what criminal law tends to protect. Access to valuable opportunities, which a lot of socioeconomic rights, well, some of them, I'll come to socioeconomic rights in a moment, and self-respect. So these are the four basic goods, and I say that discrimination law in particular seeks to protect our access to the last three basic goods because our membership of vulnerable groups like women or racial minorities hinders access to these goods. Now, Cora's question is a good one, and my response is this. Of course, it is likely that members of vulnerable groups also lack access to the first basic good more than members of other groups. So in other words, racial and religious minorities are more likely to be poorer, more likely to starve, more likely to not have adequate clothing. That's absolutely right. The mechanism by which discrimination law works, however, is different from socioeconomic rights. So I think that social rights and welfare rights are directly concerned with the first good of keeping body and soul together, as it were. And social rights have started engaging with some valuable opportunities as well. Education is one of them. But let's focus on the first good for now. There's a key difference between how social rights work and how discrimination law works. Social rights guarantee access, at least in an aspiration sense. They guarantee access to the particular benefit at hand. So right to food, a guarantee of right to food, at least aspirationally, hopes that everybody will have access to food. Right to education, at least aspirationally, hopes that everybody will have access to education. Discrimination law doesn't work like that. Discrimination law does not provide universal access to any benefit. It does not even provide access to a benefit for every member of the protected group. It does not say all women will have education, for example. It works in a slightly more mysterious way. What the discrimination law tries to do is to try to break the nexus between group membership and disadvantage by intervening almost randomly so it does not even say that the most needy of women will get protection first. It depends on a whole range of other factors, like who is able to bring a claim. In fact, you might even argue that discrimination law tends in practice to privilege the more privileged within the minority groups, right? And that is a design flaw which we might want to think about, right? But the women who are likely to be able to bring a claim are likely to be more privileged within women. Right? So that's the reason why discrimination law does not, as its goal, seek the first basic good of food and clothing and shelter. It has implications for how those goals. So if the state has a policy to provide food, then discrimination law will interfere and say you can't implement that policy in a discriminatory fashion. But if the state has no policy to provide food security, there may be other reasons why you might think first that the state should do such a thing. But anti-discrimination is unlikely to be the first reason you will come up with. Does that make sense?
Yes. Thank you very much. If I may ask a second question.
Sure.
So to recap, the point of discrimination law is to ensure secured access to basic goods for leading a good life, including liberty, an adequate range of valuable opportunities, and appropriate level of self-respect. I'm interested in the idea of adequacy for a range of valuable opportunities, and whether that concept of adequacy is a relative or an absolute concept. You made it very clear in your book that discrimination law is not concerned with giving individuals a maximum range of opportunities, but only adequate opportunities for leading a good life. And you mentioned that how adequacy is to be determined by what is possible. So it's determined in a relative sense. For example, what would be an adequate level of education for well-being would be determined by the level of education that most people in a particular society have. But you also mentioned that those with the best access to these opportunities today show us the limits of what is possible. How much is adequate for each person depends on this possibility and on our need. What I wish to ask is, or to flesh out, is what is the role of this adequacy threshold in the practice of discrimination law? So to give you an example, assuming that in a hypothetical society, a very, very rich society, But in that rich society, for a very long time, there has been serious discrimination of whites against blacks. In that society, the majority of the population is blacks. Let's say 70 or 80% of people are blacks. The state only sponsors them up to undergraduate level of education. So blacks would still have an undergraduate degree. But for whites, so the 20 or 30% of whites, the states, well, on average, the state sponsors them up to having 2 PhD degrees. So they have a much higher level of education. But relatively speaking, blacks are not doing that well. But still, blacks are not doing that bad because it's a very rich society. So my question is, do blacks in that society have an adequate access to education? If so, does that mean that there's no role for discrimination law to play in that society? I think a possible response to this would be that even in that society, the level of self-respect of blacks would be lower than, the level of self-respect of blacks would be harmed because they feel that they're treated in an inferior manner as compared to whites. But if that's the case, then does that mean that whenever there is a clear differentiated treatment on a protected ground, there would be a role for discrimination law? And so the issue of adequacy is irrelevant to the practice of discrimination law.
Cora, another excellent question. It actually, I'll answer it in 2 parts, and I think I'll answer the second part of the question before I move to what I mean by adequacy. So what role is adequacy have to play in the practice of discrimination law? And the short answer is almost none. Okay. And for this reason, so your question allows me to illustrate what I mentioned in passing in my book about the importance of the 2-level analysis in discrimination law. So the idea is an old one, and it comes from a debate that was taking place between criminal lawyers in 1950s. So criminal law theorists were trying to think about what is the role of punishment in society? What justifies punishment? And they were divided into 2 different camps. The one camp thought the point of punishment is to deter somebody from committing a crime. The second camp thought, no, that can't be the role of punishment, because sometimes you can deter someone from committing a crime by punishing an innocent person. So all you need is really harsh, spectacular punishment meted out to anybody. It doesn't matter whether they have themselves committed a crime or not. That will serve the role of deterrence. This other camp says the real role of criminal law punishment is to give you your just deserts. What have you done and what do you deserve? And these camps are irreconcilable. They were talking past each other. So come to the stage John Rawls and Herbert Hart. They both wrote important papers in the mid-50s, basically making the same point, that these 2 camps are not in opposition to each other, that they are answering different questions. To the question, what is the general justifying aim of the system of punishment? Why should we have the system of punishment to begin with? They say the answer is indeed in deterrence. We need to have the system of punishment to stop people from committing crimes. But the distributive questions, who should be punished, and when, and how much, these are answered by the desert theorists. That cannot be answered by deterrence. And suddenly the problem seems to be resolved in that each camp will answer a different question. I thought a lot of what was going on in discrimination law debates also fitted quite nicely in this model. Applying it to your question, the adequacy threshold is relevant only to thinking about the broader picture of discrimination law. Which groups are vulnerable groups? Which groups to protect? but it should not be relevant to deciding what is an act of discrimination. There, any differentiation ought to suffice, because if you start asking the adequacy question in every single case, you will in fact make it harder to achieve the broader overall goal. So the adequacy discussion is relevant only to the big picture, systemic, general justifying goal of discrimination law. But more generally on the point about adequacy, where does the concept come from? There's a very long debate amongst philosophers of equality. And there's been a challenge to equality where people have said, look, what is the value of equality ultimately? Why do I have to be equal? Not equality in a light sense of being equal moral persons, but why should I have exactly the same goods, material, etc. as you? And that's the classic libertarian challenge to equality. And some egalitarians changed their positions, made it more nuanced. One group came to call itself the prioritarians, people who talk about priority. They were led by, it was formed by this excellent paper by Derek Parfit. It was titled, I think, Equality or Priority. And what the prioritarians say is it's not equality that we are concerned with. What we are concerned with is the situation of the worst off. In any social ranking, who is the worst off person at the bottom of society? The state has a duty to help them. That was the prioritarian goal. Another camp that came around, they were led by Harry Frankfurt, called the sufficientarians. Say, it's not priority that matters, it's sufficiency that matters. Not whether you are at the bottom, but do you have enough? Do you have adequate goods to live a good life? That's all that's relevant. My understanding of adequacy in the question you posed is a sufficientarian understanding, but one that takes some insights of prioritarians seriously. I'm sorry about all this jargon, but this is what is there in the literature. So what I say is, yes, we do care about whether you have enough, but what is enough depends. It depends on the type of society you live in, the time and place that you exist. 400 years ago, basic supply of piped water and electricity would not have been a requirement in any adequacy threshold because nobody had it. In our societies, where at least some people at the top have this access, we can safely say that these things are adequacy requirements. So the nature of society and how much the people at the top have, to my mind, sets the adequacy threshold. It pegs how much is adequate, but what we really care about is whether we have enough, and not whether I have as much as you. So that was the big idea.
Can I follow up on that point, perhaps from a totally different tangent, as I'm a practitioner more than not a scholar, not an academia. Differential treatment or sufficiency to determine whether I'm discriminated against. In practice, always rely on comparables. Do you find that mind-boggling and very difficult to gauge? What are your thinkings on getting these comparables?
Thank you. So first thing, I'll just repeat that it will be a bad idea for practitioners to apply sufficiency in cases. That is just academics sitting in the ivory tower and working things out. Please do not bring it up before the court because it will be a bad idea. Just adequacy, sufficiency. These are all theoretical thinking, but they have implications for practice, but not direct application. Your question about comparator is a very good one, and it has created a lot of problems around the world. So one problem it has created is that sometimes you don't have an appropriate comparator. And it has mainly come up in pregnancy cases. In British courts, sort of, bent over backwards trying to figure out who do we compare a pregnant woman to? And they made up things like an injured man, a sick man, a non-pregnant woman, and then finally decided this is too hard. We will give up on comparison, and all we will ask is, but for your pregnancy, would you have been treated in the way that you were? Right? So they come up with a different causation test and give up on comparators entirely in the pregnancy case. The same is the situation with disability, because again, who do you compare? Disability has so many different varieties. Who do you compare someone who's an amputee from someone who has schizophrenia to it? So that's one set of problems, the absence of an appropriate comparator. The second problem is that the comparator is, you can easily manipulate a comparator. On almost any problem, you can come up with a comparator that reaches the result that you want to reach. So there's a cherry picking problem that has also been pointed out. The third problem is the comparator is always someone who belongs to the dominant group. So sex discrimination claim brought by a woman, and if you use a male comparator, the standard is set by the man. So let's imagine a case where the police service requires every candidate wanting to become a police person to be 6 feet tall. A woman comes to court and says, look, this is discrimination because I'm not 6 feet tall. On the comparator test, the employer can say, well, I would have applied exactly the same test for a man. This is, of course, solved in law by indirect discrimination law, but you can see how the standard is set by the dominant. And in religion cases, you can see this happening very clearly when courts are saying, well, Christians are treated in exactly the same way. The fact that your religion requires you to wear jewelry or to pray 5 times a day, etc., is your problem really, because Christians aren't allowed to pray 5 times a day or to wear turbans or jewelry. So comparator has that problem as well. So in response, what South African and Canadian courts have done is basically to extend what British courts have done in pregnancy to all cases. But if you can show comparative harm, that is sufficient to establish discrimination. But you don't have to. It's not necessary in order to establish discrimination that the harm should be comparative. All you need to show is that the act in question was connected to the protected characteristic in a relevant sense. So you entirely avoid all these problems that the comparator analysis gives rise to. The UK has adopted that model only for disability and pregnancy, but Canada and South Africa have done it for all grounds. And I think that's really. So see, I saw your Sex Discrimination Act, and it does say less favorable rather than unfavorable, which is the language that the British Act uses. So I think that it'll be a good thing if courts understand the difficulties of comparators.
Other questions?
You mentioned very early on in your lecture that there's still a lot of indirect discrimination that's just getting harder to point out, especially in cases of random security checks. And you also mentioned that in major jurisdictions like the US and the UK, they're actually pulling back in terms of how willing they are to find cases of indirect discrimination. So I was just wondering what your thoughts are on how discrimination law is likely to progress in the short future.
It's a very hard question. I can tell you how I would like it to progress in the short term, because that's relatively easier. So just thinking about what discrimination law has done in the last 20 to 30 years. The discrimination law becomes important, at least in the English-speaking world, around the same time as left politics is changing. So progressive left politics evolves, at least in the West. I don't know anything about the Hong Kongese context, so forgive me if this is all entirely ignorant. In the West, old class concerns with material redistribution come to be labeled as the old left. In the 90s, with basically Tony Blair coming to power in the UK and Bill Clinton coming to power in the US, you see a reconfiguration of what left politics mean. Both these figures move progressive left politics towards center ground. One of the implications is that material redistributive socioeconomic concerns, socioeconomic inequality, fades in the background. What becomes important is identity politics, politics of recognition. So Nancy Fraser, Iris Young, they've done a lot of work on redistribution versus recognition. From the politics of bread and butter, which is the old left politics, we become interested in the politics of symbols and offense. And this is not, by the way, to belittle recognition politics. The entire gay rights movement based its politics on recognition. Recognition has done a lot of good for racial politics as well, but symbols became very important, right? Which is why we get what's problematic about this ad. Even though nobody is materially being disadvantaged, we see that putting a black man in a laundromat and whitening him is problematic because we get the politics of recognition. So I think the politics of recognition is good, and discrimination law has really been the legal vehicle to permit that politics of recognition to play out in courts. See all the same-sex marriage cases, etc. What has been the casualty are the bread and butter issues. And I think that indirect discrimination law really has the potential to bring those old left concerns. Why are women poorer than men? Why are racial minorities going to worse schools? Bring all those concerns back on the table. But it's harder. It's harder because litigation on indirect discrimination is extremely difficult. The claimant, even the courts have said we don't really need statistics, but in order to make a cogent case, in order to make a case that will win, you need to do your homework. You need to gather a lot of data. You need to figure out over time how the particular issue is panning out. Proving disparate impact is not easy. British Parliament amended the law to change the language from disproportionate to particular disadvantage, to make it easier for the claimants. It hasn't actually become easier for the claimants, but that was the idea behind it. You need to do your homework for proving indirect discrimination. So I think that the key to the direction of discrimination law will depend on two things. It will depend on first whether activists and practicing lawyers are willing to learn and work with sociological evidence. Because that's what you need for indirect discrimination law to succeed in the courtroom. They need to do a lot of homework before they file a case in the court. So that's the first thing. The second is, will our social morality change and catch up with the law? Most ordinary people do not think that there is anything wrong with indirect discrimination. Most people today get what's wrong with prejudicial discrimination, with direct discrimination, with most cases of direct discrimination. But our social morality is still to catch up on indirect discrimination. And if its legitimacy is questioned every time a case comes out, there is a horror headline in a tabloid press, the courts are part of our society. They will react, they will try to settle back the law. So I think it depends on both. And for the second issue, therefore, politicians have an important role to play. Society needs to be educated on the problematic nature of indirect discrimination as well. Otherwise you'll have backlash, and otherwise you'll have this rollback.
So question about, you had mentioned one of the justifications for discrimination law is securing the sense of self-respect as one of the liberal goods. I was just thinking, could there be, however, could there be situations where if discrimination law, let's say in a country, develops to a certain degree where actually it impinges, it hurts self-respect? Because I think of two examples in the US at least, right? One is, the phrase in the US, pulling the race card, where to describe somebody who, claims discrimination, but is actually, he has no arguments whatsoever. And so actually that reduces the level of respect people have for him. And then you had mentioned Justice Scalia, so thinking of another Supreme Court justice, Justice Clarence Thomas in the US, he's always said, his Yale degree, he went to Yale Law School, but when he graduated, he couldn't find any jobs because the perception was, oh, well, we have affirmative action policies which help minorities like him, but in the end, actually, that reduces the kind of self-respect that he has. So I just don't know. In your book, did you address that point, or
Yeah, it's an excellent question, and you're absolutely right. Of all the basic goods, self-respect is the most treacherous one. It's the most treacherous for a whole range of reasons. So it's an important good, but we have to be careful about its value, and we have to be even more careful about whether we want the state or how the state should facilitate it. So to add to some of the examples that you gave, often the state prohibition on discrimination actually mobilizes the dominant community, which feels under threat. Right? If you're used to privilege, non-discrimination feels unfair. So all minorities, all dominant majorities actually claim victimhood in many societies. Right? In India, the Hindu nationalists say they are being victimized. In Britain, the Christian fundamentalists say they are being victimized. Right? So discrimination law also organizes a backlash, especially if it's done without adequate political homework. I've already mentioned affirmative action, which is, I argue in the book, a key tool for discrimination law to use. But even affirmative action has the potential to actually have these, to reduce self-respect of groups. So your fears are absolutely valid. There's another fear with self-respect, is that it's a bad thing for a liberal state to encourage thin skin. It's a bad thing for us to take offense easily. The value of free speech that underpins the liberal state is premised on the right to offend. Right? If we become too thin-skinned, if we start protesting every film that we think depicts our group badly, every play that has implications for our group, there's a problem with liberalism. There's a problem with another liberal value of free speech. Right? So for all these reasons, we have to be very careful about self-respect. What I argue in the book is that the state has to be cautious when it is directly addressing self-respect. So the best way to address self-respect is by providing the groups with adequate, all the other three basic goods. Self-respect is closely tied with the other basic goods. Right? If you have adequate housing and food and shelter and opportunities, etc., you're likely to be better able to have self-respect. Right? If you lack those other three basic goods, then you're more likely to lack self-respect as well. But there's some design issues that you can use to reduce what I've called in the book expressive costs. So these worries that you highlight, I call them expressive costs. There are costs implicit in expression by the state of meanings and ideas. Right? So one of the big ideas that I've used in the affirmative action chapter, for example, is the concept of indirect affirmative action. So direct affirmative action is, say, the Hong Kong University says, look, we don't have I don't even know what is your typical minority group. Okay, let's just speak of women, right?
Well, Indians and Pakistanis.
Okay, so South Asians, right? We don't have enough South Asians. They are the most vulnerable group in our society. So we are going to have an affirmative action policy for Indians and Pakistanis at Hong Kong University. And one can immediately see that that has both expressive benefits but also potential expressive costs for the targeted beneficiaries, for the intended beneficiaries. One way to mitigate this, and this may not work in all circumstances, is to think about indirect affirmative action. Basically, indirect affirmative action puts indirect discrimination, turns it on its head. Indirect affirmative action is designing affirmative action policies using facially neutral criteria which disproportionately benefit the group you want to benefit. It actually came about in an American case called Fisher. Well, the Fisher what happened was the Texan Supreme Court declared race-based affirmative action in the University of Texas unconstitutional. University of Texas thought, well, how do we get around this? They also realized that Texas, the high schools in Texas were in practice racially segregated. Most black people went to certain schools, most white people went to other schools. So Texas adopts a new policy. We guarantee admission to the top 10% of the graduating class in every high school. No mention of race. It starts getting more black people than it ever did under its race direct affirmative action policy. Right? So that's an example of indirect affirmative action, which reduces some of these affirmative expressive costs. That's context dependent. In some contexts, it depends on what the politics around it is. In India, for example, a lot of people have argued that instead of direct caste-based affirmative action, if you have affirmative action based on whether your mother went to university, it will largely target the same group, but will also be perceived as a lot fairer by the dominant groups. So there are some techniques that the law can use by smarter regulation to reduce the expressive costs. It's a very pertinent question, but it's not entirely avoidable, and you always need to keep testing what the expressive impact of your policies actually are.
Thank you, Dr. Khaitan. Wonderful to see you again in Hong Kong. I've got two questions. The first one is I'm still thinking through about sufficiency and self-respect. The very much public used example of, say, members of a certain disadvantaged group doesn't need service in this particular service provider. That person can be referred out. But then, obviously, I would think of that as in contradiction with self-respect. And I'm thinking about Ilan Meyer's idea of minority stress and and even not the actualized experience, but the unexpectedness as well. So I was thinking, like in that case, some oppositional groups may say that is sufficient. And I was sort of thinking around that. And then the other one is about, I was wondering whether you could enlighten us about your views on exemptions as well. Particularly because you mentioned about discrimination law usually protects the more privileged groups of disadvantaged groups. And increasingly, then I'm thinking about exemptions as whether it's perpetuating further stereotypes or is it helpful in different ways, and that's particularly very relevant to the Hong Kong context when we bring forward discussions on sexual orientation, gender identity, and intersex status discrimination, or the possibility of it.
Thank you, Tim. Good to see you again too. So your first question, see, the number of times I'm using this distinction, this shows you how central the distinction is to my book. Don't go to self-respect directly. Self-respect, like the other three basic goods, underpins the general structure of discrimination law, but I wouldn't start asking in each particular case, how is self-respect panning out? Any expressive or material harm in any case should suffice. So you will not bring in adequacy in particular cases. So yes, telling you that you can go and get your cake from that other shop next door, stop bothering me, I don't serve people like you, is a problem for discrimination law. Even if it does not reduce my adequacy level below the threshold. And that distinction is entirely based on the systemic and particular cases. Your second problem about exemptions, yeah. So, most liberal rights are subject to limitations and exceptions. I've argued in the books that what the law calls exemptions in discrimination law statutes and justification, they broadly fall into two conceptual categories. The first category is the category of justified discrimination. The second category is, you would have labeled, permitted discrimination. And the distinction is a conceptual one, a theoretical one. Courts only talk about exemptions and justifications, and quite rightly, judges are not academics. They shouldn't, they're different roles altogether. But this is the conceptual distinction. By justified discrimination, I mean discrimination an act which is discriminatory, directly or indirectly, it has a disparate impact on the group, etc. But which, because of the legitimate interests of the discriminator, the employer, the state, etc., is outweighed in that particular case. So think of a policy that has disparate impact, but is genuinely required for the purposes. So the university using your high school grades for admission. Now, I'm not suggesting that that's a good predictor of your ability to flourish in university. That will depend on evidence. Let's assume, for the sake of argument, that it is a good predictor of how likely you are to do well at university. If that assumption is true, then even if high school grades have a disproportionate impact on particular groups, it may be justified. I'm still not saying it will be justified, because it depends on whether the university has other routes to decide. So it depends on what the alternatives available are. What you don't want to do is to shut down legitimate business. That is not the objective of discrimination. And discrimination law never requires employers. It may sometimes impose costs. Right? Saying that you cannot discriminate against on pregnancy is costly to employers. But that's different from saying you cannot pursue a legitimate enterprise altogether. Right? So discrimination law permits justification. And that's a simple cost-benefit analysis, simple proportionality analysis to say, in this case, whose interest is weightier, the claimants or the employers? That's justified discrimination. Permitted discrimination is different. Permitted discrimination takes place when the claimant's right against discrimination clashes with a liberal right that the discriminator has. It is usually freedom of religion. Sometimes free speech or freedom of association are also entangled. Now, these liberal rights protect not just your right to do good things, but also your right to do bad things. Freedom of expression protects not just speech that is good, but also speech that's hateful, offensive, lies, etc., within limits. So the question is, well, sometimes, even when the action is discriminatory and not otherwise justified, it may be right for a liberal state to tolerate it because of its commitments to other. Anti-discrimination is not the only thing we care about. We also care about freedom of religion, freedom of expression. The question is, again, which of those freedoms is weightier in that given context? And that will depend on a whole range of, so I'm not saying religion should always win out. But even when religion wins, the state should be very clear that we are not endorsing your discrimination. We are tolerating it. And I think that, and which is very different from the message the state gives to an employer whose discrimination is justified. In that case, the state says, yes, tough, too bad, the outcome is bad, but you are not acting wrongly. You are pursuing a legitimate objective through proportionate means. That's a very different outcome from saying, we'll let you do it, but we don't like it. Does that make sense?
Any other questions?
The earlier statement about freedom of speech mentioned that the liberal state should not encourage people to thin skins. One question that may be confronted in anti-discrimination legislation is that what happens, when should the state intervene when certain speech has direct impacts on people's subjective feelings of security or the ability to access certain socioeconomic goods? For example, historically abusive works for black people, gay people, and so on and so forth, which creates implication of personal insecurity. Should it be involved in anti-discrimination law at all, or should it be in the realm of, for example, criminal law?
Yeah, it's another good question. I think one will need a theory of free speech to properly answer that question. One immediate hunch I have is that discrimination law is civil law. So its encroachment on free speech is by definition less than any encroachment by criminal law. So if an encroachment is justified, it's more likely to be justified under civil legislation than under criminal legislation, right? Because if you criminalize an act, the state is going after you in a much more heavy-handed manner than through civil legislation. That's not entirely determinative of the issue. I'm reminded of some of the tests that the US Supreme Court has come up with under the First Amendment. Is it called clear and present danger test, where if your speech produces a clear and present danger of violence, then it can be prohibited. I'm wondering whether that should be extended. I don't have clear answers for that, but I'm generally very careful about too broad a regulation. I think certain types of speeches are problematic. I'm less worried about regulating speech from elected officials, because the state does not have the right to free speech. Its officials may in individual capacities, and there is a conflict when they're wearing the official hat and the private citizen hat, but the state as an entity does not have freedom of expression in the way that private. So the state, or at least officials when speaking for the state, must stay on the straight and narrow. They must speak carefully and not say homophobic or sexist, and they're justly criticized when they do. Right? The second response I have is often the best response to bad speech is more speech rather than a ban on the speech. So hate speech, when it stops short of having further implications, maybe the best response is to use it as an opportunity for the community and the state to positively counter it. Or maybe the Prime Minister or the Chief Executive to come publicly and affirm the values that speech denies as a community. Right? And these are all, this relates to the earlier question about expressive harms. These are complex questions, and each society's response will differ. I did a paper in 2013 on the role of dignity in discrimination law. And basically, dignity has been a vehicle to bring in these expressive ideas into discrimination law. When we say my dignity has been violated, what we are really talking about is something about self-respect expressions. Right? It's hugely complicated and very difficult for a liberal state to handle. I don't have clear ideas, and this is more generally a problem about the politics of recognition and identity politics. We all know the good it has done. We also understand its limitations. Identity politics liberates you, but it also puts you in a box. Right? And that's another dilemma of this expressive politics. So I don't think, well, I don't have clear answers. I think it'll depend on the context. But it's an issue that must be approached with great caution.
Well, I'm looking at the clock. Thank you very much, Tarun. Please join me in thanking presentation was excellent. Thanks for drawing so much relevance to Hong Kong. It has been really insightful to listen to.
Thank you. It's been a pleasure. Thank you all for coming. And thank you, Tarun.
Thank you all.
University.